Well, good afternoon, everyone. Thank you for joining us. My name is Russell Korobkin, and I have the honor of serving as the Dean of the UCLA School of Law and the great pleasure of getting to welcome you here today. Before we begin, even though this is a virtual event and most of you are not actually on campus, I do want to take the time to acknowledge that the UCLA School of Law sits on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. And as members of a land-grant institution, we at UCLA acknowledge this and pay our respects to the ancestors, elders, and relatives, past, present, and emerging. All right, welcome to the latest installment of our From the Frontlines webinar series. In these challenging times, we are at UCLA Law are fortunate and proud to have so many faculty, alumni, and friends who are among the foremost experts in the legal, social, and political issues that are of current importance. The UCLA Law's Native Nations and Policy Center advances the laws and institutions of Indian nations, and our Tribal Legal Development Clinic, that's part of that program, connects law students directly with tribal leaders, officers, and attorneys to provide legal development services to Indian tribes. The Native Nations program is really one of the gems of the law school, and we're proud to be recognized as a national leader in this field. So today we have some of our faculty and an outside expert as well to join the conversation. We have with us Angela Riley. She's professor of law and Native American studies here at UCLA and a special advisor to the Chancellor on Native American and Indigenous Affairs. And also, on top of all that, director of the Native Nations Law and Policy Center. Joining her, we have Lauren Van Schilfgaarde. She's an assistant professor of law here at UCLA and also a graduate of the law school. And they will be joined on the panel by one of the other leading experts in the country on these issues, Kristen Carpenter. She's Council Tree Professor of Law and Director of the American Indian Law Program at the University of Colorado Law School. The panel will be moderated by our San Manuel Band of Mission Indians Director of the Tribal Legal Clinic, Mica Llerandi. And as a reminder, before we start, please send any questions that you have through the Q&A feature in the webinar. And the panelists will be able to, Mica will be able to share those questions with the panelists a little later on in the hour. So with that, I'm delighted to introduce Mica Llerandi and turn it over to her. She'll give a little more in-depth introduction to our panelists and get the conversation started. Mica?
Thank you, Dean. Thank you for the introductions. My name is Mica Llerandi. As Dean Korobkin has already stated, I'm the San Manuel Band of Mission Indians Director of the Tribal Legal Development Clinic. I'm a member of the Navajo Nation, and today I will be the moderator of the panel. It is my great pleasure to introduce our three panelists. First, we have Professor Angela Riley, who is a member of the Citizen Potawatomi and is a professor of law and American Indian Studies at UCLA. In 2003, she became the first woman and youngest justice of the Supreme Court of the Citizen Potawatomi Nation of Oklahoma. She has served as a Chief Justice since 2010. Next, we have Professor Lauren Van Schilfgaarde, member of the Cochiti Pueblo. She was also a former member of the San Manuel Band of Mission Indians Director of the Tribal Legal Development Clinic. And before that, she was the Tribal Law Specialist at the Tribal Law and Policy Institute. Lauren grew up in Albuquerque, New Mexico. Finally, we have Professor Kristen Carpenter. Kristen Carpenter, in addition to being Professor of Law at the University of Colorado School of Law, was appointed to the United Nations Expert Mechanism on the Rights of Indigenous Peoples as its member from North America from 2017 to 2021. She currently serves as Justice of the Shawnee Tribal Supreme Court and the co-lead of the implementation project with colleagues at Native American Rights Fund. She is a graduate of Dartmouth College and Harvard Law. Today, we are here to discuss protection of sacred sites. More specifically, we are doing it through the lens of a case involving Oak Flat, a 2,200-acre parcel of land in the Tonto National Forest, located roughly an hour east of Phoenix, Arizona. The fight for Oak Flat began roughly 2 decades ago and involves Indigenous rights, religious freedom, a call for green energy solutions, public lands, private companies, and congressional action authorizing the sale of public land to a private company. It very much sounds like the storyline of a political thriller. Oak Flat is the center of Apache cosmology and religious ceremonies and holds special significance to 10 tribes in Arizona. Oak Flat has drawn support from a variety of faith-based organizations in Arizona and across the United States. Apache individuals continue to visit Oak Flat for ceremonial purposes and for harvesting traditional medicines. Recognizing its importance, Oak Flat was listed as a traditional cultural property on the National Register of Historic Places in 2016. And the National Trust for Historic Preservation listed Oak Flat as one of 11 most endangered historic places in 2015, because, as they state, it currently is threatened by the mining that would forever destroy the tranquility of this spiritual place. Despite this recognition, Oak Flat is where copper ore has been located and where a large mining project, Resolution Copper, is attempting to occur. Resolution Copper, owned by Rio Tinto and BHP, will use block cave mining to extract copper ore, a process that will turn the sacred site into a huge crater, ranging approximately 2 miles wide. The mining project is proceeding due to a 2014 rider on the Defense Authorization Bill, where Congress approved the transfer of land to Rio Tinto and BHP in exchange for land elsewhere. Resolution Copper asserts that the copper will be used for electric vehicles, smartphones, and MRI scanners. And the mining project is said to also bring jobs to the area. We have very limited time today, so I'd like to turn it over to our 3 experts, Professor Riley, Professor Schilfgaarde, and Professor Carpenter, who will talk us through the implications of religious freedom and the First Amendment, the environmental review processes, and the green economy, and Oak Flat in the international context. We will reserve 15 minutes for Q&A at the end. Again, please add your questions to the Q&A box and we will add them to our queue. To start us off, Professor Angela Riley.
Good afternoon. Thank you so much, Mica, for that introduction, and to Dean Korobkin. It's really lovely to be here with my colleagues and my dear friend at Colorado. So thank you all for joining us. I know we have a lot of people out there. Some of you are probably in Indian country and some of you are probably new to this issue. So we're excited to be able to talk to you about it and explain some of the legal issues that are happening in this case and similarly situated cases around the United States. In my limited time to start us off, I'm going to focus on a couple of things. I want to start by giving a little background on Oak Flat, although you already heard some of the context from Mica Llerandi. And then I also want to say a little bit about the one piece of litigation that's currently making its way through the courts in the effort to save Oak Flat. And then I want to pull back and talk a little bit more broadly about First Amendment claims with regards to Indian religious freedom and Religious Freedom Restoration Act claims as well, and explain how they relate to sacred sites litigation. So to start us off, as Mica already said, this case involves 2 foreign mining companies, Rio Tinto and BHP, who plan to open through Resolution Copper, a copper mine in what is now the state of Arizona. And if it proceeds, it will be the largest copper mine of its kind in the entire world. As you've already heard, this is a site that is sacred to the Apache people. They conduct ceremonies here. Young girls go through a coming of age ceremony here at this site. And in Apache religion and cosmology, this place is sacred and it is imbued with sacred elements, not just in the flora and fauna and everything that's included there, but also in terms of its own spiritual meaning to the Apache people. It's also a national park, as you heard, which is currently managed by the United States. So you might be asking, just as an initial question, if this is Apache sacred land, how did it get into the hands of the United States in the first place? This is probably not a huge surprise to many of you out there. The Apache people, like most indigenous peoples on this continent and elsewhere in the world, were at various points removed from their Aboriginal territories and eventually confined onto reservation in the nearby area. But that reservation doesn't include their sacred places, including Oak Flat. This, of course, is a story that has played out time and time again in the United States. Many of the sacred sites cases actually that we see come up, including this one, are sacred sites that are located on lands that are now not within tribal control, sometimes on private lands, but not infrequently on federal lands and federal public lands. But as Mica mentioned, the history behind Oak Flat is actually more complicated than that. And I think that it's an important piece of the story to bear in mind how this land swap actually happened. This land has been protected at least since the 1950s, even though it's federal public land, because of its enormous natural beauty and cultural significance. There have been efforts to try to open this land up to all kinds of extractive industry over the last decades, and those have been resisted time and time again, including explicitly in 1955 and again in 1971. So there are activities, of course, that happen on federal public lands, including mining, cattle grazing, and others. And this site has explicitly been excluded from those kinds of activities or the mining activities in order to protect it. But what happened in 2014 is that two congressmen attached a rider at the last minute to a bill that had to pass. As Mica mentioned, it was a defense bill that was sort of understood as a must-pass bill. It was attached right before the vote on the bill at the very last minute, and because the bill was seen as one that couldn't not pass, it passed along with this rider that allowed for a land swap, where the United States would give this land, which includes the sacred Oak Flat, to the mining companies. And because of the nature of this, it all happened really without public scrutiny. So one of the sort of fundamental issues in the case is how that land swap happened. And of course, how and to what extent the United States can get around its own constitutional obligations to Indian tribes by giving the land to a company that isn't bound by the Constitution. And again, these are two foreign companies. These are not American companies. And Professor Carpenter will talk more, I think, in her presentation about exactly what is going to be extracted here and who it is going to benefit. So as a result of this, situation, ultimately, you see Congress handing over sacred holy lands to a foreign-owned company, probably for the first time in American history. So because of this, the United States has the authority, at least the purported authority, to transfer this land and to allow for mining by Resolution Copper. As Mica already said, the scope of the project is enormous. It's around 2,400 acres of land. During its operation, it will span around 2 miles wide and be about 7,000 feet deep. One other thing to keep in mind is that even though this is an enormous repository of copper, it will be entirely exhausted in 50 years. So 50 years from now, there will be a big gaping hole in the ground where Oak Flat and other sites used to be. At that point, with mitigation efforts, it will still be 2 miles wide, but about 1,000 feet deep. It also will destroy much of the water in the region that is needed for humans and other living things. It's going to use around 250 billion gallons of water, or that's equivalent to enough water to supply a city of 140,000 people for 40 years. The use of water is in part because water is used to separate the copper from the other useless minerals once they're extracted out of the ground. So I want to say a little bit about the litigation, and Professor Carpenter is going to talk about various parallel litigations and litigation strategies that are going on with regard to Oak Flat. But I want to just say a couple of words about Apache Stronghold versus United States. So this is the particular case that was brought by a coalition of tribal members and allies and others against the United States, arguing that the proposal to transfer this and to open it up to copper mining is a deprivation of their First Amendment rights of religious freedom, because it goes without, it's essentially going without debate that the site will be utterly, completely, and permanently destroyed. So any religious ceremonies that would happen there will no longer be able to happen. The Apache Stronghold brought this case under both the First Amendment and the Religious Freedom Restoration Act, which is a statutory protection that purportedly gives greater protection for religious freedom than the Constitution, and I'll say more about that in a second. The case was heard at the Ninth Circuit. Apache Stronghold lost. Then the Ninth Circuit voted to rehear the case en banc, and that case was heard in March. I was there in attendance along with several of the people on this webinar, and many of my students and my children. And I will leave this more to the Q&A, but I will just say it was remarkable to hear the United States argue as our trustee for American Indian tribes that what it's doing here violates, not only does it violate the Constitution, but it has no trust obligation to act otherwise. So you might be asking then, for those of you who aren't familiar with the field, what's the connection between sacred sites and religious freedom in the sense, and in the constitutional sense? So as you all are well aware, our Constitution enshrines protection for religious freedom under the First Amendment. It's one of the most revered and robust protections in our constitutional structure. At the same time, however, Indigenous peoples have argued for decades and decades, if not hundreds of years, that they too have a right to religious freedom, and that right to religious freedom should also be protected by the First Amendment. But the reality is that Indian religious freedom is not protected in this country. The Supreme Court has failed to protect Indian religious freedom, and in fact has ruled time and again that the First Amendment doesn't protect American Indian religions. You also have to kind of think about this in context. Indian religious freedom in this country has not only been squashed and oppressed, it has been criminalized. People have been massacred for practicing their religion, including, for example, the ghost dance, the sun dance. Sacraments have been criminalized for certain periods of time, like peyote. Gathering of sacred elements like eagle feathers has been made difficult or impossible under certain circumstances. Indians were enslaved in Catholic missions in order to get them to convert. Indian children in boarding schools were also forced into Christianity. So this is a long, long sordid history of the oppression of Native religion. But despite this, the First Amendment should protect Indian religious freedom, but it does not. In Ling versus Northwest Indian Cemetery, which is sort of the seminal case, the Supreme Court held in a case where the building of a road was going to destroy a site sacred to several tribes of the region, including the Yurok, the Talawa, and the Karuk, that it would not violate their First Amendment rights to religious freedom, even though it would completely destroy the road and the site, and would completely destroy their ability to practice their religion there, because the Supreme Court said because they weren't being coerced into a particular religious belief. And I'll let my colleagues talk a little bit more about those claims later. That case was followed by another one called Employment Division versus Smith, where the Supreme Court again held that it was not a violation of the First Amendment to deny unemployment benefits to an American Indian practitioner of the Native American church that used peyote as a religious sacrament. Excuse me, as long as the law was valid, neutral, and generally applicable. Interestingly, we see as a response to Smith, we saw the passage of the Religious Freedom Restoration Act, which was supposed to provide more protection for religious freedom. And interestingly, it has in some respects. We have seen the Supreme Court become more solicitous of religion over the last decade or so. We have seen RFRA interpreted broadly to protect the religious freedom of corporations, like in the Hobby Lobby case, protect the religious freedom of religious organizations, like the Little Sisters of the Poor case, protect the religious freedom of people who want to decline to bake cakes, or churches that don't want to hire women, and the list goes on. And yet we are seeing virtually no examples where either the First Amendment or the Religious Freedom Restoration Act are being used to protect the religious freedom of Native people. Apache Stronghold, of course, is raising these issues absolutely directly on the nose, and we are awaiting an opinion in that case. So it will be, of course, we're all anticipating that opinion and want to see how the Ninth Circuit is going to handle that case. My expectation is, regardless of who prevails in that case, there will be a petition for writ of cert to the Supreme Court, but that's something we'll just have to wait and see. So with that, I would love to turn it over to my colleague Lauren Van Schilfgaarde to talk about some of the other issues in the case involving various administrative protections. Thanks.
Thank you, Professor Riley. So as Angela went over, there are a lot of really glaring things about this case that are also really emblematic of issues that Native people across the continent and the globe face, particularly when they have been dispossessed of their lands and are still trying to access and protect their sacred places. So she detailed a lot of the claims that are being framed as religion or spirituality or cultural protection that are currently being litigated in the Ninth Circuit en banc. Another vein of strategy, particularly here in the United States, tends to orient around environmental protection. This is in part because statutes like the National Environmental Protection Act, as well as the National Historic Places Protection Act, offer unique opportunities for tribes to participate and hold the federal government accountable for pursuing procedural requirements under things like NEPA or the Clean Water Act, or et cetera. So they tend to be procedural arguments, but they include things like tribal consultation that are sort of the big hooks that tribes have to participate in this litigation, particularly for claims that are taking place off tribal lands. There's a whole universe of law in the ways in which these laws are applied for on tribal lands, but because Oak Flat is no longer considered tribal territory, the tribes are compelled to make these off-reservation arguments. Okay, so again, I know we keep harping on it, but I keep getting distracted by how massive this project is being proposed. 7,000 feet deep is equivalent to bigger than what the Sandia Mountains are in relation to the city of Albuquerque, where I grew up, which, the city of Albuquerque sits somewhere between 5,000 and 6,000 feet. Sandia Peak is upwards of 10,000 to 11,000 feet. And so 7,000 elevation gain is bigger than what the Sandian Mountains loom over Albuquerque. It's so incredibly massive. Now, what was one of the many unique things about this literal midnight rider that Senators McCain and Flake were successful in, facilitating this land exchange was a requirement that the land exchange shall take place. It's a mandate. There is no federal discretion on whether or not to give this land over to Resolution Copper. But the procedure is they have to do so within 60 days of the completion of the final environmental impact statement. Okay, ding, ding, ding. So in addition to the religion claims, the San Carlos Apache tribe, along with varying coalitions, depending on the litigation, starts to hone in on this environmental impact statement. Sort of akin to leading up to the land exchange, which was initiated after 13 different bills, lots of different congressional hearings. Subsequent to the land exchange, we now have a seemingly politicized environmental impact statement process. The San Carlos Apache tribe filed some litigation in 2016, in part because the federal government had, pursuant to this land exchange, issued a, quote, decision notice and finding of no significant impact. They weren't even going to do an environmental assessment, basically saying we can skip that step, no problem. The San Carlos Apache tribe said you at least have to do, even by pursuant to this legislation, you have to do an environmental impact statement. It's clear as the environmental impact statement is being conducted, there are pretty serious concerns with the substance of that, in addition to what's going to be this immediate bomb ticking clock that goes off as soon as it's issued. the tribe gets word that the environmental impact statement is imminent. And so a day before it's set to be released, January 15th, on January 14th, the San Carlos Apache tribe issues an emergency appeal to say like, no, like, what are we going to do here? And this environmental impact statement drops. Now, if you'll remember, January 15th, 2021, that was a turbulent time in DC. It's also the very end of the Trump administration. And so this was literally like 3 days before there was a change of administration, which is not a coincidence. On March 1st, before the emergency injunction appeal from the San Carlos Apache tribe is even comes to term, the Forest Service withdraws this last minute environmental impact statement that had been released by the Trump administration. That was sort of interesting. In part, it was sort of unclear, but the Biden administration released a memo saying in part that the withdrawal of this environmental impact statement is out of concerns that there was insufficient tribal consultation. And so it's like, totally agree. Okay, here we go. In 2022, just last year in June, the Bureau of Land Management, in response to the Biden administration, did their own assessment of what this environmental impact statement had said. This is not typical to have sort of like a different administration doing a sui sponte review of what this report had. So they do their own technical report. It was also kind of funny because their technical report was, they published it in June 2022, but it wasn't really public until September. So however, 7 months ago or so. This report, it's a 22-page technical report, eviscerates this federal impact statement. They are very critical of the way in which this environmental impact statement was conducted and basically go through a number of different shortcomings. Some of those shortcomings include a real failure to assess for the impacts of climate change that this mine is going to have, failure to adequately consider the impact of water, as Angela mentioned, especially groundwater. But even if we didn't look, the fact that 256 billion gallons are going to be used in a state that, not coincidentally, is currently enmeshed in massive water settlement lawsuits and negotiations regarding the Colorado River, amongst others. And so it is intense. There's also specific concern over their failure to account for the waste dump and some of the toxic mine tailings that are going to be produced, in part because those mine tailings are going to be in perpetuity, even though the life of the mine is only expected to be 50 years. And so that's sort of where we're at right now. It's not clear yet whether or not a new environmental impact statement is going to be produced. If it does, what that would look like. In theory, we could just revive this existing environmental impact statement from the Trump administration, even with this BLM report, because there's not really any like binding precedent that says like, oh, well, this technical report says this is no good. It's just kind of out there. And so we're just sort of sitting. There is proposed legislation, though I don't think any has gone out of committee, to undo the land exchange itself. But that's a congressional political fight, and we'll see how that goes. In addition, there is another series of litigations in state court in Arizona in which the San Carlos Apache tribe has challenged the applicability of the Clean Water Act, specifically in relation to this mine. In part, there was advocacy that there was not a sort of new source of water that was going to trigger new regulation under the Clean Water Act. From what it seems, the Arizona Court of Appeals knocked down the lower court that said like, oh yeah, this isn't a new source. And the Court of Appeals said like, Yes, it is. This is definitely a new source as part of the shaft. This is real technical Clean Water Act deals, but it is currently pending before the Arizona Supreme Court. And so we may anticipate, especially based on this Court of Appeals, some new restraints as far as Clean Water Act regulation goes, but that's procedural and it doesn't necessarily undo the land exchange or the mine itself. It just adds some new barriers in regards to the Clean Water Act. But that's sort of like a litigation update, but also sort of a snapshot into some of the other legal tools in the toolbox that tribes frequently rely upon as a roundabout way to protect a space, but I think also as an explicit marriage of the reasons why these spaces are so critically important to tribes. It is both cultural and environmental. Those two are not necessarily wholly separate for a lot of tribes. And so I think there's a lot of substance here, but it's also primarily a procedural critique and a challenge as opposed to a substantive one. And so I think with that, I will turn it over to Professor Carpenter to help us get a better, broader sense of what's going on in this litigation. Professor Carpenter.
Thank you, Professor Van Schilfgaarde and Professor Riley, and first to the Dean and Mica for your kind introductions. I have the opportunity to talk about this case from an international law and human rights perspective. And before doing that, I guess I'd like to acknowledge that the people really on the front lines, of course, of this litigation are Apache lawyers, for the most part, who are really mounting a multifaceted approach that I think you've heard from Angela and Lauren, and now from me, that involves federal law, constitutional law, and statutory law, state law, and advocacy there, both judicial and legislative. And then increasingly, the San Carlos Apache tribe has been going to international venues, including the United Nations, I think because of the fact that that law that Angela described with respect to religious freedoms in the United States is so limited. It really prevents many tribes from getting past a threshold argument. The courts have for a very long time held that the federal government can destroy a sacred site without substantially burdening religion. That's pretty much a hard place to litigate from because it obviates the need for the tribes to even, or for the government to even show that it has a compelling interest in the project. And I think in Indigenous peoples' rights, it is often the limits of federal Indian law or constitutional law as applied to Indian tribes that causes many of us to look to international settings, because every time we hit that ceiling in the US, we still have a client or a community who says, well, now what are we going to do? Let's say the Ninth Circuit rules against Apache stronghold. Let's say it goes to the Supreme Court, as Angela said. I'm hoping and praying as a matter of justice and equity that the Supreme Court would extend the protections of the First Amendment and Religious Freedom Act to Indian tribes. But history doesn't suggest that that's the likely result. And so I've been pleased and encouraged to see some of the tribes turn to international instruments and venues. And in my own work, it's been helpful to step back a little bit and think about some of the human rights that are at stake. And when it comes to the freedom of religion, it was really the World War II and the desire of the world community to never again discriminate against people on the basis of their religious identity and their religious practice such that it would amount to a genocide. And the Universal Declaration of Human Rights recognizes that every single human being, just by virtue of being human, has the right to a conscience, to religious beliefs, and also to religious practice, whether in public and in private. And when you read the Universal Declaration of Human Rights and remember that history that led the world community to come to consensus around that Article 18, I think it's poignant to remember, how much was at stake, how much was lost then, and unfortunately, how much is still at stake for American Indian tribes today. There are more than one tribal leader who has talked about the destruction of an indigenous way of life as a form of cultural genocide. And when it comes to Oak Flat, as Angela said, this is a place where young girls have their coming of age ceremony. Some of the lawyers I know, their own daughters have had their coming of age ceremonies there, their mothers, their grandmothers. It's a place of continuity of Apache life and religion and spirituality. And so this is, a very serious matter and something that I think quite rightly should be considered as triggering universal human rights. We have a particular document, the UN Declaration on the Rights of Indigenous Peoples, that contextualizes universal human rights in the Indigenous peoples context. And it recognizes that Indigenous peoples need access to their sacred places, even sacred places that have been taken from them, as in this case, through the history of conquest and colonization. And it's really up to nation states like the United States to figure out how to accommodate those rights to ensure that Indian people, just like everybody else, again, as a matter of equality, can enjoy those rights. I saw in the chat some questions about additional international instruments. Maybe we can talk about those in the Q&A. But I guess I'd like to talk in my remaining minutes about the utility of going to international forums to advance rights in cases like this. On the one hand, any strategy that's involving international advocacy and diplomacy is realizing that this is a long-term proposition. If we think that federal litigation takes a long time, international diplomacy really takes a long time. These meetings happen once annually. There's a series of them. There's a lot of ramp up time and energy and expertise that lawyers and clients need to develop to effectively advocate in international venues. But the upside is that once you opt in to that community, there's this whole amazing world of solidarity among Indigenous peoples that tribal leaders and tribal lawyers can work with. So just last month, a number of us were at the United Nations Permanent Forum on Indigenous Issues with the San Carlos Apache tribe. And Chairman Rambler made a very powerful statement to the forum, witnessed by representatives of most of the 193 national state leaders and Indigenous delegates from all over the world, and called out the United States for violating not only the First Amendment and RFRA, but this international universal right to religion. This starts to trigger a process of diplomacy where the United States, which likes to think of itself as a beacon of human rights, is called to account for why it is undertaking these activities, which will so adversely, if not completely, destroy the right of a people to exercise their religion. This is a whole process of reports and statements and letters back and forth that are somewhat tedious, but they do suggest another set of levers for trying to get the attention of the State Department, the Interior Department, in this case, the USDA, with respect to the issues on the table here. In addition to bringing attention to national leaders, national departments, a number of Indigenous leaders are working to develop solidarity, as I said, with other Indigenous peoples around the world who are facing similar problems. And so at the United Nations, the San Carlos Apache leadership met with the Australian Aboriginal people who had a terrible experience with this very same mining company, Rio Tinto, which completely destroyed, this is already in the past, a sacred site to them a number of years ago. And interestingly, the Rio Tinto people were so excoriated and faced such financial harm that their board of directors had said at that time, never again will we violate Indigenous peoples' human rights in a way like we did in Australia. But sure enough, here they are doing it again, which is somewhat shocking. It suggests that the worldwide commitment to human rights by business entities, it has not fully permeated some corporate responsibility departments. But one thing that I think the San Carlos Apache people took from the conversation, and not to speak from them, but for them, but just something I observed, was that they then had the opportunity to appear at an annual general meeting of Rio Tinto, and Chairman Rambler made a statement straight to the board of directors and straight to the shareholders about this human rights violation that Rio Tinto is about to engage in. And again, it's another lever going straight to the companies. And this is an international company, as Angela said, a multinational company with business. It's co-owned by Australian and UK interests. 16% of its shares are held by Chinese entities. So international law, international human rights definitely should come to bear on a case like this. And I think the Apache people are pursuing that strategy in a really smart way. Finally, before I wrap up my comments, the other international standard, in addition to the universal right to religion, is the emerging norm of free, prior, and informed consent. And under the UN Declaration on the Rights of Indigenous Peoples, states have to obtain the free, prior, and informed consent of Indigenous peoples who will be affected by undertakings like this one. And Lauren already mentioned that in US law, there are obligations under several statutes of US agencies to consult with tribal governments. But for the most part, that consultation has been deeply criticized by commentators like us, because often the agencies just check the consultation box and they go ahead with the project anyway. And there's nothing in the law that stops them from doing that. The world community has realized that check the box consultation is not enough to protect Indigenous peoples' human rights. And so the standard is one of consent, of mutual agreement, of a process that puts Indigenous peoples, national governments, and corporations in this instance at the table with enough information and enough power to negotiate a mutually consensual agreement. And I think it's not only as a matter of equity and justice, but also as a matter of risk minimization, that companies have decided that embracing this standard of free, prior, and informed consent benefits them, because as we're seeing with Oak Flat, as we all saw with the Standing Rock case a number of years ago, when companies and states don't work with Indigenous peoples to cultivate a mutually agreeable arrangement, it leads not only to litigation, but to delay, sometimes to protest, to arrests, to subsequent human rights violations. This is not a good way to do business for corporations, and it's not a good way to advance human rights by nation states like ours. And so I'm pretty pleased to see Indigenous peoples in the US going to the international arena, invoking these instruments, participating in the institutions, and working together on those problems. I'll stop here and look forward to the discussion. Thank you.
Great, thank you all. So we have a variety of questions coming in through the question and answer box. Again, if you have any other questions that you want to have the panelists ask, please jump in and chime in or put it in the question and answer box and we will get to them. There are quite a few questions that were just generally related to how can we, pulling through. Let's pull first to the international questions. Professor Carpenter, you did note that there was one that you already saw. I think combining the two of them together, Professor Pat Gonzalez-Rajas and Leonard Gorman asked a similar set of questions related to international arenas. Specifically, Professor Gonzalez-Rogers writes, while I certainly see the solidarity of international Indigenous community via the UN construct, that said, the US, regardless of administration, has never been a signatory to the Declaration of the Rights of Indigenous People, and further has historically shown a great institutional ambivalence to conforming and or signing on to these international frameworks. Thus, what is the practical implications or lack thereof in contemporary time to participate in such activities? Similarly, we do have a question, or connected to it, we have a question from Leonard Gorman, the Executive Director of the Navajo Nation Human Rights Commission, who says that while international binding treaties require the U.S. to protect sacred places, or which international binding treaties require the U.S. to protect sacred places off demarcated Indigenous reservations? So we'll turn these over to you, Professor Carpenter.
Well, thank you for the opportunity to get into the weeds on international law, and I'll try to keep it brief, but I love this topic. So starting with Executive Director Gorman's questions first, and I know he's one of the most knowledgeable people about this work, and the Navajo Nation Human Rights Commission has been very active in using international law to advance protection of sacred sites. So the binding instruments of international law that we could look at are the International Covenant on Civil and Political Rights and the Convention to End Racial Discrimination, both of which are fully binding treaties. The US is a signatory, actually, of both. And they are kind of like the Universal Declaration of Human Rights, general. They apply to every single person in the world. And they prevent states or prohibit states from engaging in racial discrimination. That's CERD. And I'll go back to Angela's point, perhaps, when she said that the First Amendment and RFRA have been construed to protect the religious freedoms of Christians, of Muslims, of Jewish people, of practitioners of Santeria and Wicca, and you name it, but not of American Indians. That's racial discrimination. That violates CERD. That violates, I think, Article 2 of CERD, and I could go through the list. CERD has an early warning, early action procedure that actually the US is subject to by virtue of being a member of that convention that we could pursue. The US is, as the other question implies, still very reluctant. It's not like the Nordic countries or some others that really care about what the international community thinks. But nonetheless, that is the law. And when the US doesn't abide by the law, it's an outlier in the world community. You could also look at the International Covenant on Civil and Political Rights, Article 27, which pertains to the rights of minorities. It includes to practice their religion, and you can use those in conjunction with the declaration or on their own. And I'll just say briefly with respect to the status, of the UN Declaration on the Rights of Indigenous Peoples. As a declaration, first of all, it can't be signed. It has no signatories. This is my technical international law professor hat. It was adopted by vote of the General Assembly. The US first voted against it. It subsequently reversed that position. It, along with all other 193 nations of the United Nations in 2014, pledged to support the declaration. So in terms of indicating support, the US has done everything it can as a formal matter in international law. The task now is to implement it in domestic law. And that's what we see countries all over the world doing. Canada just passed legislation to implement the declaration fully in Canada, Mexico City, New Zealand, you name it. We're behind in the US, but we've got to catch up. And that's a project with the Native American Rights Fund called the Implementation Project, which UCLA has also worked on. We're all about doing exactly that. So thank you.
Thank you. Professor Victoria Sutton just wrote a comment that I wanted to share with you all. She wrote that the Biden administration on January 21st issued executive order claiming no metals essential to national security would be mined and taken out of the US. Rio Tinto plans to export almost all of the copper produced from the proposed Oak Mine flat. Really hoping that the Biden administration would speak up. Professor Sutton and Viviana Prado also write a similar question related to the requirement of the EIS being published. Wouldn't it have, why was this requirement of the EIS being published included in the rider, and wouldn't it have been easier for the for Congress to simply transfer mandate the transfer without the EIS? And do you think the state would withhold permits from Resolution Copper or the BLM, who was so critical of the EIS, or withdrawing support or withdrawing approval of it? So anybody want to chat a little bit about the EIS process and kind of why this EIS additional requirement was added in?
Kristen, well, I know you have more context than I do on this, but so I can speculate. The rider itself includes not only like a requirement for this environmental impact study, but it's a land exchange. And so the land, Oak Flat, being given to Resolution Copper is an exchange for land that Resolution Copper had owned, and that they specifically mark in the legislation as, oh, I forget the term they use, but they intended, it's an acknowledgement that that Oak Flat has significant cultural, religious, and spiritual significance for Native people. And so they intend this new land to sort of replace that and to be accessible in hopefully a culturally significant way. So the writer itself envisions that this exchange land is going to hopefully alleviate some of the concerns that were clearly expressed in, the congressional record for these 13 failed preceding bills. There's also requirement for tribal consultation as well, in addition to the environmental impact study. So again, I'm speculating based on the words on the page. There was clearly concern about the outcry leading up to this rider and an anticipation that there was going to be concern afterwards. And so, they could have made a legislative exception for themselves around MIPA. They did that to a large extent, but still kept portions of it. So I think it's important to note that this was still a very extreme deviation from what should be the norm, but they also, I think, were making an acknowledgement of what the norm is, but also what the political reality is.
Anyone else want to jump in, or we good? All right. Okay, we have a couple of questions relating to really Professor Riley up your area. How can laws protecting Native religious freedom be tailored enough as to not grant wide latitude to discriminate to majority groups, e.g. Hobby Lobby, Masterpiece Cake Shop, etc.?
Yeah, it's a great question. I mean, I have to just confess from the beginning that my vision of the legal framework that leads to the protection of Native religious freedom doesn't have to be cabined by and constricted by the First Amendment jurisprudence. So in my intellectual universe, when that first case is brought, when the lien case is brought, and the United States is deciding whether to build what they themselves agreed was a marginally useful road through an Indigenous sacred site on lands that the United States promised then took from Indigenous people. And the United States has acknowledged from essentially inception as part of its plenary authority over Indian affairs that part of its plenary power over Indians is an equal and opposing duty of trust, that the United States is our trustee, and therefore it owes obligations to Indian nations to act in their best interest and to protect them. They've spent hundreds of years dismantling Indian religion and trying to physically and metaphysically kill off Indigenous people and Indigenous culture. So if the tide has turned, if the trust responsibility is to mean anything, then Ling could have gone to the Supreme Court on First Amendment grounds, and the Supreme Court could have said, even without opening a floodgate of expanding what the First Amendment means writ large, that a common sense approach to First Amendment protection for Indigenous peoples who have land-based religious practices and to whom a duty of trust is owed, these are special cases. That if you are going to permanently destroy a site that is sacred to Indigenous people, it can never, ever be restored. It's not a church, it can't be built somewhere else. You're facing this existential question that the First Amendment common sense approach plus the trust responsibility puts these sacred sites cases in a unique category. And to me, you know, that's a world that we don't live in, but it is it's an intellectual, in my view, it's an intellectually honest, it sticks to the Constitution. And so therefore you could have a narrow approach to the First Amendment across the board if you have concerns about, for example, minority rights, the rights of women, the rights of LGBTQ people, et cetera. You could still find that balance within the First Amendment jurisprudence and still protect Native religion. That's a fantasy land. That's not where we are, but that's how I would think about those cases. But I want to just concede that it's a, you know, it's a small needle to thread, right? And it's a difficult balance. But that's sort of how I think about them.
And then another question we have is, somebody writes in, I'm curious about the idea of sacred and how it relates to property. Is there a stable genealogy around the concept, or are there competing traditions or perspectives? For Indigenous communities, is there both an assimilation usage of the sacred versus a view of the Indigenous sacred as distinct from colonizers? For example, the land is sacred.
Well, I'll just say one sentence. Yes and no. And I'll just point people, if they're interested, to Professor Carpenter and I, along with another friend of ours, Sonia Katyal, wrote an article now more than 10 years ago called In Defense of Property, that applies some property concepts and contemporary human rights concepts to Indigenous property, especially Indigenous cultural property protection. So you might find it interesting. Yale Law Journal, it's very long, so don't have to read the whole thing. But I guess I would just say, one thing that we argued in that paper, and that I think is true of Indigenous advocacy in the US and around the world, is that there are two things happening. One, to a certain extent, like we went to law school, right? I went to an American law school, so I've assimilated some of American law and American legal thinking into my advocacy. So it's certainly there. It's you know, part of my own kind of education and upbringing as a lawyer. But at the same time, there's also a strategic mechanism that we have to use the language of the colonizer to some extent, so that our claims actually have resonance within the courts. So even, for example, calling these religions is not really right. It's not really what these are. They're not religions. They are cosmologies, they are worldviews. It's both broader and deeper and bigger than that, but there's not a real word for it. So religion gets used and the First Amendment gets used because it's the best legal hook that we have. So I think you kind of see both things happening. I think there is an evolution in the way people use terminology and think about things. And then I think there's also a strategic component to it. I know Kristen and Lauren, you probably have something to add there.
I would only add how striking it was in the oral argument at the Ninth Circuit en banc, this the federal government continuously coming back to, it's our property. Don't we get to do whatever we want with our own property, including give it away? That I thought was really just striking.
Okay, to wrap us up, one final two-part question. Do you think the best strategy was the environmental route, the First Amendment route, a sovereignty approach, or an international law approach, or a combination of them all? And what are some action items going forward?
Well, I'll say briefly, yes, this is an all hands on deck moment. Everything that the questioner asked, I think, is being demanded of the tribal lawyers and the tribal people. And I think that, you know, a lot of these stories are about law, but they're also about the community and the ongoing practice of the religion, the belief, the cultural revitalization, you know, standing their ground. And I mean, just yes, I mean, everything from tribal, state, national, and international law and society is going to be required to stop this mine and save Oak Flat.
And I just want to add one sentence to this. I'm not going to advocate for any particular call to action, but activism is also a big part of this story. And what happened at Standing Rock was the result of activism, and it raised these issues to a new level. The outcome may not have been what people ideally wanted, but it shifted the conversation in a radical way. So I just shout out to all the activists out there and all the people who are thinking, what would the next step outside of the courtroom be? Because I think there's a place for that.
All right, and we are out of time. Thank you all so much for joining us, and we will have this posted on the website, and for folks who are asking where this will be posted, it will be on the UCLA Law's YouTube channel and so forth. So it will be recorded, or it has been recorded, and it will be posted for all to view again later. I'm sorry we didn't get to answer everybody's questions, but we look forward to having you all follow up with us if you have any further. Thank you.
Thanks,
Thank you.
everybody. Thank you, Micah.